there are certain non-financial services also which the banks want to use, like maintenance and everything. But the companies which are offering the services, they are asking for cloud data. So we are mixing everything. Especially the AML thing.
I was going to ask you, so I've got significant interest in legislation that affects payments, anti-money laundering, and depends on the audience today, but if we talk about issues to do with cryptocurrency.
Yeah, and you would like to know that what, because we are always behind the time. Industry is moving fast, and then we catch up later. Initially, they come to us and we say, no, it's not possible. Then after a few months, they will be
So are you seeing ICOs and initial operations about happening in Pakistan?
No, we are not. Actually, there people are participating in the international ICOs, but not officially not.
It's not allowed.
Yeah.
Okay, so it's really interesting.
Yeah.
So we're seeing new kinds of ICOs in business, 9 different kinds of tokens, so security tokens based on high assurance identity. Those are not really interesting, but it's the anonymous ICOs. What I think about today are being rejected.
Being a central bank, my problem is that I need to take care of the interest of the corporate forces, especially if there's a bubble burst, then they will start.
So that's the speculation. Currency, absolutely. I've seen it.
What is the official point of view of the
So the official view is, we know we're going to have cryptocurrency institution, but what we want to have is a trust model. It's got to be a trust model, governance model, because it's a real time. So if you look at what's happening in Estonia, for example, what are they doing residents? It's part of the showing people living in Estonia, that's like doing business, trading, so Estonian company so 10 years for Pakistan. So the Pakistan citizens already need residence to have it. So that allows you to recharge with the Estonian government with others and supports all the normal functions with that. And that's obviously notified. Europe, for example. So it's interesting about how that British citizens in Estonia don't show legally will be able to access system in France for French business.
so virtual residence?
Sorry?
Virtual residence.
Yeah, well, yeah, absolutely. And this is
Real global village.
well, it's really, you're absolutely right. So what we're starting to see, so I know that there are Saudi citizens who've got this already. US citizens over 2 several countries have been sat with it, the Netherlands, Germany. They realise now, you've got to look at this differently. Because of the nature of the business, because of the nature of the individual activity.
Who is kind of overseeing all this process?
So that's one of the reasons that we do not have an organisation like that. But I would be very interested to follow up with your so what another reason the report and the previous report very obvious. That helps. So much work. My question is, what is like this? You can't stop. What are you doing? What are your countries?
You see, we had our meeting and we were issues on that. And we made a working group. So we can do this adoption and so we especially we have a difference of point of views. And people have their own study of the subject and we have their own point of view. But there is not official what they do and we try to find it out. But I suspect that we are following the kind of other regulators like federalism and that they are constitutional things.
Yeah, but one of the
The recent boost has come because of this registering of these my personal view is that this is better than other forms of money movement because at least you have private ownership of the stock. You can just distribute it and you can more secretive means of classification.
No one online can hear me. I'll just tell everybody that we're going to...
Yeah.
Good morning, everyone. We are just waiting on a minor technical issue to be worked out so our online participants can join us. So just a few more minutes and we'll go ahead and get started. Good morning, everyone. Thank you for joining us today. I appreciate you coming in this early in the morning for our session. As we get started, for those that are listening online, we are working out any remaining issues. However, we don't want to lose any of the time that we have allotted, so we will begin. That being said, we do have one online presenter today, and when we do get to her, I would ask that the earpieces that you have in front of you, you can go ahead and put those on so that you will be able to hear her presentation. And we will start with her as soon as we are confirmed that our technical issues are resolved. That being said, I'd like to introduce myself. My name is Frank Pace. I'm with the University of Groningen and work with the Security, Technology, and E-Privacy Research Group. My focus with the university is management of EU-funded law enforcement and security projects. I have a background in law enforcement from the United States. And joining me today online is Mrs. Mariangela Biasiotti from the Institute of Legal Information Theory and Techniques at the Italian National Research Council. Immediately to my right is Mr. Jan from Europol Data Protection Office, and next to him is Mr. Christopher Kelly from the Massachusetts Attorney General's Office, and Marcus Hartman, Senior Prosecutor at the Office of Cologne, and we have Mr. Ken Pennington, Superintendent with the PSNI, and to his right is Mr. Patrick Curry with the BBFA joining us as well. So to kick off our meeting, if you have read the introduction to our session, we are focusing on what I think you've probably seen as a common theme here at the IGF and also on the forefront of a lot of issues related to internet governance, and that is the cross-border access to information by law enforcement in criminal investigations and counterterrorism investigations as well. There are many issues right now that are on the forefront, including current pending court cases in the United States, legislation both here in Europe and the US as well. And with that, our desire, our goal today, is to have each one of these panelists who are intimately involved in each one of their respective fields to elaborate on the realities of how this is affecting the law enforcement operations both here and in Europe. We will begin with the presentation from Jan, and that is going to be on the perspectives of the Europol's data protection functions, and we'll leave this with Jan.
Okay, thank you very much, Frank, and good morning, everyone. It's a pleasure to be here. If I could put the slides on, indeed. So when preparing the presentation for this panel here, I thought about ways on how to go about this. And if you can go to the next slide. What you see in the background now are fairly recent headlines, basically. Could you start the presentation? Could you go to, yeah. So what you see raining down now are fairly recent headlines, and what is common here in that theme is basically that all of them could be a topic for this panel. I just let them rain down while introducing myself. So, as already mentioned, my name is Jan Ellermann. I'm working for Europol's data protection function for now a little more than 10 years. And before that time, I served as a public prosecutor in Germany, which I think is also a valuable experience for the job I'm doing right now. If you switch to the next slide. So the common theme basically for all the things we will discuss here on this panel, as far as I'm concerned, is that it's always about security and freedom. And what you see here on the slide right now is a quote from Bruce Schneier, basically, whom many refer to as the godfather or rockstar of security. And back in 2008, he made this quote, so he said, "Security versus privacy, it's the battle of the century, or at least its first decade." So there are many legends surrounding this gentleman. One of them, if you go to the next slide, is this one here. But that is not what I wanted to talk about. So basically what I wanted to talk about is whether, to the next slide, please, whether it is a good idea to talk about security versus privacy and whether it's not possible to do a little bit better than that. So basically, I'm personally convinced that if we do it right, if we want to get it right, we need to increase both freedom and security. So we need to move away from the tune freedom versus security, and that is what privacy by design and data protection by design is all about. So I found this looks very cool. So me and the famous Bruce Schneier on one and the same slide with 2 quotes and me even correcting him. So the truth is, of course, if you go to the next slide, there are a lot of very smart people who agree with that assessment, basically, that it's not freedom versus security, but it's both, and that includes Bruce in later publications. I would like to issue a small warning here, because I think if we want to have a reasonable debate about this topic, basically, we need transparency. You request transparency on many occasions, and I have a number of slides with me which shall illustrate basically what we are exposed to in the law enforcement world. And there are some very explicit ones included. So referring to the EU Internet Referral Unit, I've joined or I've listened to a panel where referrals were discussed yesterday. So basically, referrals are about monitoring online content, Islamist, extremist, terrorism, propaganda in the case of Europol, the EU Internet Referral Unit. And when this was introduced, basically, there was a huge debate on whether or not that constitutes the beginning of an internet censorship unit within the European Police Office. If you look at the next slide, basically, this is what we are really looking at. So this has nothing to do with freedom of expression, but this is what our colleagues are exposed to, and this is what we are trying to prevent, next to things such as this, so what we call Hollywood-style propaganda. So this is basically propaganda which is tailored to lure vulnerable people, in particular young people, into the hands of the Islamic State. We look for this kind of propaganda, and we inform the internet content providers basically about its existence, recommending deletion. So what the next slide is about is to show that we don't have enforcement powers here. So it's not like we would decide as law enforcement that needs to go offline, but basically we inform the Twitters, the YouTubes, and the Facebooks that, to our opinion, what we see in this particular context is non-compliant with their own rules and regulations. As you can see here, you could do this afternoon or right away on your smartphone. So my message here for you is, every average internet user could be doing the same. So the lady you see here on the slide, that's my grandma. It's really her. So she's 97 years old. I've told her how Twitter and things work, so now she's online 24/7 to fight the Islamic State. This is, of course, classified information, has to stay here for her protection. But there are other angles to that. So the next one is basically, that is a screenshot relating to an investigation into sexual exploitation of children. And I give you just a few seconds to read through that, because that is what is probably most efficient here. So if you're reading that, basically what you see is these are atrocities. That's not just about physical abuse, that's about psychological abuse. And my message here for you is we need the tools to effectively prevent and combat these things which happen online, and that's reality. So when I read that, I found it really shocking. On the other hand, I'm of course also aware, as a member of the data protection community, that many of you argue whenever it gets complicated, law enforcement plays the terrorism card, and afterwards you play the sexual exploitation of children card. And well, I do that here because that is the reality we are confronted with, but it's not limited to that. So if you look to the next slide, basically, this is a screenshot from the darknet. Here somebody can order, you could order easily a handgun with a silencer. So I can ask you, what are the necessary business cases for a private person to order a handgun with a silencer? There are none. And there are hundreds out there, thousands out there, which you can buy with a mouse click. To conclude my presentation here, I want to convey the message to you that we take privacy and data protection very seriously. So what you see here is a quote from the Executive Director of Europol, clearly acknowledging the necessity to have a robust data protection regime. At the same time, I think we need a public debate together with you on how we can get it right. And with these words, I conclude. Thank you very much.
Thank you, Jan. Moving on to Chris. I would like for Chris to elaborate a little bit on his background, your current efforts and challenges, and those that you've worked on in the past. And the floor is yours.
Sure. Thank you and welcome to everybody this morning. My name is Chris Kelly. I run a cyber forensic lab for the Massachusetts Attorney General's office. It's probably one of the larger such labs in the, certainly in the Commonwealth of Massachusetts, but probably across the country in the U.S. But I've also been a prosecutor for the past 15 years, focused almost exclusively on cyber cases. So what I'm going to do is talk about some of the emerging issues, legal and policy issues that we see in the U.S. and how they're shaping what we do every day in law enforcement in terms of our forensic investigations, our cyber investigations, as well as any other non-traditional or traditional types of criminal cases that we use digital evidence in for the purposes of detection, investigation, or prosecution. We have some rather significant challenges like everybody else in the U.S., but with the number of major providers that we have there, they're increasingly complex. And there's two major cases that are before our Supreme Court in the United States that could have a profound effect not only on law enforcement and public safety in the U.S., but also globally with the way that they play out. So the first is one that's probably less well known on the international scale, and this is Carpenter versus the United States. This was a case that was heard before the Supreme Court just in the last month or so. And it's a case that deals with law enforcement's surveillance of a suspect in a bank robbery case. There was a court order that was issued for cell site location information to a provider, to a cellular provider. Over the course of 3 or 4 months, they determined exactly all the different movements for this particular suspect, ultimately tied him to a series of bank robberies that he was tried and convicted in and ultimately sentenced. The case was heard before the Supreme Court, and the challenge in this case is whether the U.S.-based law enforcement should be using search warrants for the purposes of tracking a person for that period of time, based on the constitutional needs, in dealing specifically with the Stored Communications Act. So the Stored Communications Act is a federal statute that all state, local, and federal law enforcement must adhere to for the purposes of demanding that third-party providers, so cellular providers, internet service providers, social network providers, email providers, et cetera, provide information to law enforcement in the course of investigations. So we deal now with these different the different security interests and privacy interests and balancing those with public safety interests. And it's a very difficult conversation sometimes to have. And it happens in boardrooms, it happens in courtrooms, and it certainly happens before all of our different legislative bodies now. The Carpenter case we don't have a resolution in the Carpenter case, but indications from the court were rather significant that questions to the government about how much surveillance is too much, how much is, what type of order should be necessary for law enforcement to enhance what they could do visually by tracking somebody using the technology. So we don't necessarily have an analog to what we're dealing with when it comes to this digital realm that we're in. And courts now are wrestling with some of these issues and having a difficult time. It'll be interesting to see how this case comes out because of the third-party doctrine issues that we'll see in the wake of that. The second case is perhaps far more significant and certainly salient to the conversation that we're here to have today. And this is the what has become known as the Microsoft Dublin matter, or the Microsoft Dublin case. And it deals with U.S.-based access to data that's stored on, or that was stored on a foreign soil in Ireland. So the way this case came to be is that federal law enforcement applied for a search warrant for data held by Microsoft. They were granted that search warrant. And when they went to execute that search warrant, they received certain information back from Microsoft, but then the response from Microsoft was that other data was stored overseas, and that this was content data, and they couldn't provide that data to law enforcement. There was a series of challenges that went all the way up, and now the case is before our Supreme Court. And the question now before the court that they have to deal with is this: does the federal U.S. Stored Communications Act allow for essentially the claim of extraterritorial jurisdiction or extraterritorial application of our search warrant capability? And this is a question that deals with not only the legislative history of the Electronic Communications Privacy Act going back to 1986, but also additional constitutional dimensions and challenges that we'll see play out. So far, I think a total of 36 states in the United States have come out in support of the Department of Justice's position when it comes to this petition. And several district courts, federal district courts, have also come out and ruled in the opposite manner from the Second Circuit, and therefore made it right for the Supreme Court to have heard this case. The case is going to be, there are a number of legislative and policy considerations that surround, but the case is refined to this very, very small issue of whether the Stored Communications Act does or does not allow for this type of application of the search warrant. Obviously, this has an impact on international, cross-border data sharing, and it'll be very significant to see how this case turns out. You want me to keep going on?
Anything else you want to cover?
No, I can come back to it later. I don't want to keep.
All right, thanks, Chris. Moving on, I'm going to go to Ken from the PS&I, and the perspective that we want to have Ken relay to the audience is that of the challenges and the realities of what is occurring on the ground in law enforcement at the investigative level. And with Ken, I'll let you expand further.
Thank you. I have approximately 30 years in policing, spanning a period of conflict. And whilst this may appear somewhat of a diversion, I mention it by way of reassurance. If there's one thing I've learned, it is that the application of the law is a mechanism and not a rationale. Why are we doing these things? And fundamentally, whenever we came to deal in the field of counterterrorism, we needed to establish legitimacy, or can I say it in a simpler term, trust with communities, that we would use whatever powers we were given in an appropriate manner. And what I found is in any form of investigation, it's not security versus privacy, it's rights versus rights. We will have the rights of a suspect, and they are a suspect. I don't determine their guilt. So I'm going to have to consider what rights I'm going to engage, but I also have a positive obligation to protect the rights of others, the potential victims, the people that you saw in Jan's examples. I have an obligation in law to act. So I have to balance those two factors. When I come to balance those things, I have a number of tests. I have to be proportionate. So the level of intrusion I will be looking for will be the minimum that I require in order to achieve my reassurance that I am meeting the positive obligation to protect the rights of the others. And it will be a sliding scale determined by the level and severity of the offence that I am considering. I also need to have a legal power. I can't act without a legal authority. I act on behalf of the state, and hence the importance of getting powers in place to allow me to act. I also need to be accountable. Whatever decision I'm going to take, I need to provide an audit trail, I need to be responsible for it and be prepared to stand in a court of law and defend it. Because my proportionality test could be subjective. It needs to be tested. My interpretation of the law may or may not be correct because that changes over time. And my final test for normal policing is necessity. Do I need to do this? So when we look at these powers, those are the tests I will apply. What I would add to that in this realm of cyber is timeliness. Some of the processes we have, letters of request, the mutual legal assistance treaties and so forth, can take up to 6 months. In that period of time, we are still seeing people's rights engaged, their right to life possibly being put at risk, their right to private life, security and liberty, all being put at risk whilst we are going through that due process. And indeed, that time frame will be prioritised by the host country, not us. It may be postponed by the host country if they have a parallel investigation ongoing. What I'm hearing from the ground is some of the problems around cloud storage access, and indeed the legislation that we may have nationally may not be fit for purpose, and we're having to interpret it, current legislation, to just get some action. We also have the problems of hackers using stolen servers from another jurisdiction, a very big challenge for us in trying to gather information which might assist us. Cryptocurrency, the ability to connect a virtual wallet with a real person. That has to be done so quickly that we can really only do it currently in the most serious of cases, which means criminals are basically getting away with criminality. The darknet and encryption presents us with difficulties. We have ways of getting around those difficulties, none of which I can really discuss here, but none of them are quick. None of them are easy, and none of them come without a financial cost. ISPs, when we're working with them, what I would say is generally helpful, however less so around large-scale hacking and ransomware, and that's an area we might see on the increase. I suppose as a law enforcement officer, whatever we develop, I would like to see it being future-proofed, if at all possible that is. But the reason I ask for that is that what I see is that legislation tends to be national and tends to be slow to develop, but these technical problems and technology tends to be international and quick to develop. So there are going to have to be new mechanisms to address this problem.
Thank you, Ken. Certainly a lot to digest, and we do welcome your questions at the conclusion of our presentations, and we will try and make up for some lost time. With that being said, I will move right on to Marcus Hartman, and I know Marcus's presentation is ready, so the floor is yours, sir.
Good morning, everybody, and thank you for joining us. I would like to give you a quick overview about practical cybercrime cases and the implications that the given legal situations have. Just to start with, a few quick words about my team. I'm a senior prosecutor with the Cologne Prosecutor's Office. This office is responsible not only for the Cologne district, but for the whole of the state of North Rhine-Westphalia. Those of you not familiar with the topography of Germany, North Rhine-Westphalia is one of the 16 states and the biggest. It has about 18 million population, and about 1/3 of Germany's top 100 companies are located in my district. So we have quite a few high-profile cybercrime cases that my department is in charge of. One of these cases I would like to pick just as one example is the Patriot Ransomware that I think all of you have heard about recently. What has happened is that a ransomware, a piece of malware that is encrypting all user data and thus preventing the use of the computer and asking for a ransom, has spread through some clever compromise of an update infrastructure of an Ukrainian-based company that delivers with a special software for filing taxes and dealing in general with the Ukrainian authorities. So what happened is that this software did not only cause a lot of damage in the Ukraine themselves, but in the whole of Europe and abroad, because every company that has business relationships with the Ukraine has to use this software and thus got infected through the compromised update. So basically, this is just one example of how such a simple thing as ransomware can make an investigation from the very start a huge international case. And I would like to stress that every of these cases, every high-profile cybercrime case, is an international case. There's no such thing as local or even country-based criminal investigations in the field of cybercrime. And we have to take that in mind and have to keep that in mind and take that for our considerations as to how the legal framework for addressing these cases has to change. I would like to present you with a few ideas of what could be the keys to success in order to fix the present situation. First, I would like to mention that what you started already is speed. If we don't get access to data relevant to the investigations in time, we don't get access to the data at all, because data that is delivered to us with a delay will lead us into non-existent discovery of further investigations. That means if we don't get the data in time, we cannot seize the servers, cannot arrest the data abroad, and in fact, all the investigation might stop if data access is not presented in a timely manner. Whether this could change through an improvement in international legislation, maybe allowing direct access from one country to another, or whether we would fix this matter by investing more resources, people and technical resources into the given system of mutual legal assistance. It's not relevant to fixing the practical issues, but we need to recognize that we have to do something about that, because speed is the main limiting factor at the moment. Second, we need to deal with efficiency of investigations. At the very moment, we have lots of discussions ongoing with all types of organizations, with companies, and everybody is developing his own system for law enforcement access. May it be an online platform, may it be via traditional means of phone calls, fax systems, whatever. We need to find some sort of standards that allow for quick and efficient cooperation. We need to establish some sort of level of trust in the international community, so that every prosecutor can see already by evaluating the formal grounds of a request whether this request comes from a party that is a respectable party and should be followed or not. For example, we have no agreed standard of shared and encrypted and authorized communications among law enforcement on a global perspective. Somebody is using PGP, the next are using SMIME, and this is another technical issue which has to be dealt with on the grounds of efficiency. And the third one, I would like to think about the prosecution on an international scale as something like an international team. I would like to see at some time in the future distributed prosecution clusters. Let me come back to the example I presented in the beginning of my talk. The Patriot case, well, not Patriot Ransomware. Law enforcement is organized in Germany on a state, not on a federal level. That means we have 16 states in Germany alone investigating this NotPetya case. If you see it in a broader perspective, we have all the states in Europe affected. We have global infections. Do we really have the need that every state is investigating this case on its own? Everybody is analyzing the malware on its own. Everybody is following the data and the financial trails. So I think we have to find new ways of cooperation, and we have to find legal grounds in order to organize such a form of distributed prosecution among a global law enforcement community. That's it for now. Thank you.
Thank you, Marcus. Very, very valid points, and I think to focus on the immediacy of need of access for law enforcement data is one of the key ones, as well as the efficiency. And these are all topics that we're seeing that are discussed and mentioned by companies like Microsoft and Mr. Brad Smith and Mr. Kent Walker from Google, and even recent comments from former Attorney General Eric Holder from the United States, all essentially point to a lot of the issues that do have to pertain to the MLAT procedures and the access of information in a timely fashion. With that being said, we are going to move on to our last panelist, and Mariangela will be online. So if you would please, if you put your earpieces on, you'll be able to listen to her, and we will go ahead and let her begin as soon as we are connected. Okay. Mariangela, if you would please, you can go ahead and share your screen with your presentation, and we can begin.
Yes, we can hear you.
Yes, we can hear you. Thank you very much, Maria Angela. Thank you. Before we get into questions, before we conclude the session, I think the presentation that you just observed is a good example of the efforts that have been underway both in the EU and abroad over the last several years to address both the technical, policy, and societal questions and challenges that are very much a part of this topic. With that being said, I'll take the remainder of the time to open up the floor to any questions, any one of our panelists. Yes, sir.
My name is Amjad Manzoor. I'm representing State Bank of Pakistan. I just want to ask the panel, what is being done at the level of the UN? Because maybe EU has a wider ownership of the countries, but lots of these threats are generated from outside EU and other countries. So is there any effort of sharing of especially the speed and the efficiency you said? Because we also find this phishing emails also coming in, and they are using this Yahoo email accounts, and they don't share the data of the sender. So that's is there anything being done on the UN level?
I'll let Patrick address that.
So my name's Patrick Curry. Bit better if I press the button. My name's Patrick Curry. I'm from an organisation called BBFA, which is a not-for-profit, which was created after the collapse of the UK National Identity Scheme. My background is military, aerospace, high assurance, cybersecurity, counter-fraud, and identity management, particularly identity management. And to come to this point, the short answer is a joined-up approach at the UN level. I'm not aware of anything at all. And my suggestion is a very simple one. Criminals collaborate. They don't feel hampered by borders. And if we're going to deal with these kinds of challenges and make places safer to do business in all its senses, then we need to collaborate more effectively. And what we're seeing is industry having to do that. So if I look at the banking sector, in Europe they are currently looking at 18 new pieces of legislation, because this is how governments respond. They produce legislation, but they don't actually put in place the behaviors for collaboration to occur. And in that legislation, the top legislation that's driving progress is the Anti-Money Laundering Directive, which now includes virtual currencies, the Payment Service Directive 2, which includes the requirement for secure customer authentication at a very detailed level, which impacts way beyond the financial sector into all retail, and general data protection regulation, so privacy. So why do I mention this? To get back to your point. I'm just going to illustrate this. In the EU and in many other parts of the world, nations have cybersecurity strategies. And the EU cybersecurity strategy, one of the big problems was the top enabler for crime was identity fraud. And so within Europe, we've seen a rise in identity management related legislation and ID initiatives, and we talked about the Estonian e-residency and so on. So the requirements for identity to give accountability and traceability in supply chains, in border control, in national security, in regulatory compliance, the need is there in the prevention space. So within the EU and working with other allies and partners in the US and Asia, there has been a lot of effort looking at how we do collaborative risk management. And as part of that, some excellent work's been done. But here's the issue. There are standards in place for risk management, risk treatment, risk mitigation, risk assessment. We're beginning to see collaboration for cyber information sharing, threat intelligence, vulnerabilities, incident management. There are over 220 computer emergency response teams in Europe that have been formed within the last 5 years. But we don't have those collaborative behaviors in the investigation side. There are no standards for meaningful international standards for the preservation of evidence within systems, particularly when they're under attack. And so without effective prosecution, we don't have effective deterrence of criminals. So we keep coming into a cycle of prevention, detection, and response. And that's what happens at a government and industry level. But there's no dialogue running with law enforcement. So law enforcement is just left to do the prosecution and investigation piece without much help from government or from industry. So what needs to happen, in my view, is A, law enforcement needs to be much more involved in the development of collaborative standards. It is completely absent from that debate. B, they need to establish collaborative trust mechanisms, which we have in NATO, we have from a systems point of view, between governments, in industry, and I'm looking particularly at things like PKI Federation, high assurance, or the EIDAS activity in Europe, or the e-residency activity, which again is cross-border. None of these identity standards are being leveraged in support of prosecution, forensics, and investigation in a meaningful way today. And my personal view is I would like to see a lot more work being done in ICANN and other bodies, RIR, to help in putting together collaborative groups to start to resolve what you're talking about. But it can only happen if we ask for it.
Thank you, Patrick.
I hope that helps.
Thank you. Are there any other questions? Yes, ma'am.
Button. Can you hear me now? Okay. If I understood you correctly, you thought it was a bad thing that you could see all what the terrorists were doing, the terrorist groups, etc., etc. Why on earth would you want to change it? Why on earth would you want to take that off the web? Isn't it wonderful that these people are so stupid that they're showing us all their information, who they're friends with, where they're going, when they're going on a trip? Why would you want to change that?
Thank you very much. I agree with you as far as these terrorists are stupid enough, let's say, to provide us with leads. What I've shown you is basically the issue of Islamist terrorism propaganda. So that is out there in order to lure vulnerable people into the hands. So these are recruitment measures, basically.
off case, the Department of Justice of the U.S. argues that U.S. warrants work to compel a provider to disclose data that it stores abroad in Ireland. If the Department of Justice wins, and then the shoe is put on the other foot, and for example, a Belgian court says that a provider in Massachusetts must disclose data under Belgian law about an American without ever meeting the U.S. probable cause standard, what would the Department of Justice of Massachusetts say to that attempt to compel a disclosure?
The simple response is that there's no Department of Justice in the Commonwealth of Massachusetts, Craig. So I think this is one of those really difficult areas of this dynamic when it comes to the Stored Communications Act. There are many countries that already do have this method of compulsion for data that's stored within their own sovereign nations, and that is one of the significant, that is going on right now, and it has been for quite some time. The real key with the Stored Communications Act, with this particular case, and the way that the Supreme Court comes out, is going to be whether they decide that the compelled production within the United States is something that's allowable. So it's U.S.-based investigation, U.S.-based court order or search warrant. It is a domestic provider, so it's within the United States, and production and access to the data is also done within the United States as well. And the question is, regardless of where that data lives, should that company be compelled, or can Congress more appropriately compel that company to provide that data within the United States? And I think that that's the confined issue that's being dealt with here in the Stored Communications Act. But the short answer to your question is that lots of different countries are treating this in a similar way. Is that we saw instances of it in Brazil as well, where Brazilian authorities went to the offices, I believe it was Yahoo and Microsoft, or Yahoo and Facebook at some point in time, and arrested members of their staff that did not produce records that were there. These are obviously very difficult and complex questions that are going to be answered in the wake of this. Many of the folks that are at the table here all have come to the same conclusion that really the proper forum for this is Congress, is to deal with these on these issues by having all the different parties, stakeholders come together. And I think that communication and collaboration on this, I tend to agree with that. Communication and collaboration and people sitting down and making concessions and understanding the more broad dynamic here is really the critical factor.
I would just like to add a quick note on that. You're absolutely right. When, as a government, you ask for direct access to data that is stored abroad, you need to be ready to provide data for everybody else accessing the data that is stored on your grounds. So that is why I mentioned that I'm not ready to give up on the traditional means of mutual legal assistance all too early, but that we need to realize that the given system is on a vast level understaffed and under-equipped with resources. If we just count in different countries how many prosecutors or people within the ministries are responsible for dealing with international law enforcement requests, then the bottleneck for processing these requests in a quicker and in a more efficient way is just not the general issue of that the mutual legal assistance system is not working, but that it is not adequately staffed.
Thank you. In the back.
I realize the answer to my question depends on the jurisdiction, so I'd love to hear both an American and European response to this, which is how do or should we draw the line between legitimate speech and terrorist propaganda? So, for example, if somebody is very angry about a certain group or a certain country, or even has feelings about a certain religion and wants to express them perhaps in very strong terminology, how do we draw the line between that and somebody who we think is likely to do harm to that or other groups that we should have some kind of intervention? It seems to me, especially in the U.S., to be very tricky. I know Europe has different kind of laws on this, but I'm wondering if you folks would comment.
I can be brief on that. Hopefully, so formally we apply the definition of the terrorism directive according to EU law, so we would make an assessment down those lines. In practical terms, we indeed had these discussions. For instance, when it comes to the Islamic State, I had the colleagues of the EU Internet Referral Unit approaching me with pictures where you just saw, you know, palm trees, a sunset, and then the black flag swinging and all of that. So that is something, it is IS propaganda, but basically my advice was let's not refer that stuff because there's so much out there which is clearly within the boundaries of the definition, that at least for the time being, we don't have to go to the borderline cases. Thank you.
I'm curious, one of the U.S. colleagues, because you know, our First Amendment goes. For example, I know Germany has certain hate speech laws that would not be accepted in the U.S., and I'm curious, from our perspective, if anybody has any thoughts on that. U.S. perspective.
Go ahead.
I'm not familiar with the particular German statute that you refer to, but
well,
obviously...
for example, Nazi propaganda or even depictions of swastikas would be illegal in Germany, as I understand it, but in the U.S.,
right.
It would be considered protected speech,
right.
For example.
Yeah. So obviously the First Amendment gives you that you know, freedom of speech and protection for, you know, points of view, things that you say. It's when those, but none of those rights that are protected are absolute in their nature, right? So anytime that you yell fire in a movie and you put other people's you know, safety at risk, then you might be committing some type of offense that you know, that your words become actions to a certain extent, and those become. So it would be, it's very difficult without an example or
Yeah.
tangible to say whether something is or is not protected speech under the First Amendment. But it's all done on a case-by-case type of analysis.
Marcus?
Just a quick comment from the German perspective. It's a little bit of a misunderstanding that the hate speech laws, so to say, in Germany are vastly different from that in the US. I think 80%, 85, maybe even 90% of the cases referred to my department that are considered on the estimation of the providers to be hate speech are, when evaluated by a prosecutor, not to be considered a criminal act, but just some angry person announcing his personal opinion. So I think the cases that really ask for an answer by a prosecutor's body are of a level and intensity that can be agreed on that they should be criminal in Germany and in the States and other countries as well. Okay. So I think if you look at the practical cases, the difference margin between what counts as a criminal act is not that different from my perspective.
Okay. Quickly, Ken, you had a comment?
In answer to the question, how do you balance, you know, freedom of expression against, you know, hate speech, and we have legislation for that, I suppose the answer is carefully and proportionately. What I would say is the criminal justice system may not be the best place to start. I have seen counter-radicalization work in Malaga, which will be a pilot for the rest of Spain, where that low-level type of stuff that we saw with the banners and so forth, the first point of contact is actually social services, because the early reports are usually parents with maybe teenagers, and rather than criminalizing them at an early stage, they're trying to address what their views are, and only in the most extreme cases passing that to law enforcement.
Okay, we have time for one more comment, then we have to conclude.
In the scenario in Germany where the prosecutor determines that the speech is not unlawful, would it be appropriate for another element of the government of Germany to flag that speech to the provider as a violation of the provider's terms of service, and then get the speech removed even though it is not unlawful?
Well, this kind of work is done not by government bodies, but by non-government organizations. For example, the Providers Association of Germany takes complaints by people that come up with some postings online and refers them to the providers themselves. If you are referring to the discussion of the new Netzwerkdurchsetzungsgesetz, I don't know what the term is in English, the law that requests providers of social media platforms to delete online postings when they are considered to be unlawful. I, as a prosecutor, in my personal view, think that the right point to judge whether something is lawful or unlawful is not the provider, but the prosecutor. So we have started a project with my department, with media partners from the press and with partners from social media networks in order to streamline the process of flagging content, reviewing it on legal grounds, and deciding what has to be deleted or what has not to be deleted, and providing the necessary help to the providers and establish a common agreement on that. I think there's still lots of work to be done, and we'll see where this discussion leads us.
Thank you. Well, I would like to thank all of our panelists for their time and contributions, and for all of you for attending our sessions. Thank you, and have a great day.
That was interesting. So you have a minute? Yeah. Great. I enjoyed your presentation yesterday.
Thank you.
Yeah. Nice to have a philosopher. We need more philosophers.
Oh, well, that's an important.
Well, I consider myself an amateur philosopher. So. I think everybody should be an amateur philosopher.